we filed schedule of arrears, we filed defendant's brief on financials issues, and then plaintiff's brief updating the court on defendants, on the financial issues. So both of us on that same day filed briefs on May 8th, 2018, which precipitated the court's thorough order on May 16, 2018. Nothing's been filed since then. So this is, maybe she just forgot.
Or maybe I was just told that there was nothing paid and it shows that everything was paid. So that's why I'm just kind of confused, Your Honor. So let's go through it.
You want to have
let's go
clear?
Through it.
Wait.
No, I'm fine, Your Honor. I don't need it. I don't. Let's go ahead and do this.
Okay, stop.
Yeah.
I need it. I need to have a clear record. I want the judgment. I want the schedule of arrearages. As I said before the break, she has verified them. So your client needs to testify to them. And there are multiple pages. You said you haven't seen them. I don't want him to be prejudiced. So I'm going to print them out and tell me what other order you need.
I got it.
The one reducing to judgment?
I know.
Counsel, do you
The
agree?
May 16th, the one that's filed July 7th.
July 7th.
Because we had the child support set in one and we had the financial issue set in another. Because there was 3 separate days for trial. There was 2 separate orders. There was an order in May and then there was an order in October. The order in May was regarding the child support. The order in October was the rest of the financial issues, including everything that was reduced to judgment. So that's why it was a little confusing, Judge.
So you need the October one?
Correct.
Okay, Frank, can you give this to her, please?
And Your
Oh,
Honor,
no, You're right.
well, Your Honor, just so the court's ready, there were judgments, so you know, if you pull our register of actions, actual judgments filed October 24, 2016 for unreimbursed gymnastics, for spousal support arrears. In addition, August 14th, 2017, and if I can approach, I printed out the register of actions. And then, since the judgment, the court required me to file
Tiffany,
arrearages.
when it says judgment in red, how come I don't have an icon to click onto it?
And then, Your Honor, see the judgments at the top, that's how we do our registers here. And then after that, in May 2018, see how the judgments are first, right here? And then in May 2018, I supplemented, and those are the arrearages that have been filed since the judgment, notwithstanding what you already mentioned. And you actually summarized it in your May 16th order, this one, order after hearing me. You summarized it all for all of us after we briefed it to the court.
Do you know why I don't have that?
So these start October. Yeah.
And, Your Honor, the only thing I'm going to object to is that we have 3 things. There's no financial disclosure form, okay, that's new.
There wasn't.
All right?
We
That
filed
is new before trial, okay, because we have a new raise coming on here, and we don't have these updated, because we don't have any of the $20,000 that's been garnished on any of these pages. None of them have been accounted for. So if she's swearing under oath that she hasn't gotten any documents,
I can't click on any of these judgments.
Your Honor, if she's swearing under oath she hasn't gotten any money, then I want to know where that $20,000 is gone.
What? May
I have an
2000.
opportunity to ask her when she testifies.
I understand, but Your Honor, we have got 0 payments on any of these schedule of arrearages.
Maybe if she could see, maybe understand the prior orders. There was child support arrears, alimony, spousal support arrears, equalization payment, and
There's one for
gymnastics.
attorney's fees, there's one for gymnastics, and there's one for child support.
And the $500. Well, she doesn't know. Don't worry about it. Don't. Just the judge has it.
And all these judgments, I can't even click
We don't
on
have to
them.
cater to make her understand.
I don't understand why.
You should say everything's paid off. It's
Nothing's paid off. She doesn't.
any of them. Another reason to get it done. He's making 2 payments. The payments he's making are
I know.
the garnishments. He's not
The garnishment is for the 690, I thought it was 597, let me see.
Yeah, it is.
Is it 597?
And then a $50 arrears payment towards back child support. That's what the $50 is.
I know. Here we go.
And the gymnastics.
Right.
May I approach, Your Honor?
Well, I'm not ready yet. Yes, you can give that to Miss.
Thank you. Are you showing her the schedule of arrears?
Yeah.
Which one?
Let's do this one. He's got a schedule of arrearages for Alamo. Well, before the
Which
child
one? We
support.
filed like 3 in a row, so which
Let's do child
filed
support
it?
first, and then alimony second, and then we'll do the last one.
Just for the alimony payment. That's not. Oh, okay. And then the judgment.
Which one?
He just copied.
But here it says they'll file a schedule of arrearages to the judgment. What it is, and this decree, so I don't have an amount.
This one?
So that one will be that one,
Okay. Okay.
and then that one.
Okay.
Do you have the new one that you just had, Marshall? I got the schedule of arrearages
know which
for
one you gave
equalization. I
Lupe.
got the schedule of arrearage for gymnastics, and I've got it for alimony, but I don't have it for child support.
I don't have one.
Do you have a schedule of arrearage for child support?
That's the $50 payment
Oh.
that's coming out.
For the child support arrears of 1,050?
It's the $50 payment that's coming out.
Okay,
of
that
the-
one
Of the
has
payment.
been reduced to judgment. That's the child support arrears of $1,826, filed in August 2017, long before you got involved, for which they are garnishing $50 a month towards.
My
And this is in
understanding that he does not have any continuing arrearages
Correct.
for
So
child support
it's-
after that.
So it
Yeah.
is in my pretrial memorandum, the breakout of exactly the money that was ordered and what is being paid. So for maybe this will help council move along. The child support of $597 is still coming out. $900 alimony for 72 months was stayed beginning June 1st, but he had owed temporary support arrears of $21,400, already reduced to judgment. So I don't want to reiterate the new stuff. The arrearages that were filed, the schedule, is from the judgment date going forward.
That's why we need the judgments in the record. just
Correct.
To have
Right.
one clear record for this hearing.
And you did it, Judge, in your notice and order after the 2000, can you give me the order after 2016?
This is the 2016 order.
No. The, order after hearing May 2018, my apologies. The May 2000,
This one?
from my schedule of arrears, so.
And Your Honor, what we
Here it is.
did
Thank you.
in our pretrial, like you just testified to, is that we took your order and we went from there.
May 16, 2018.
Okay?
So Judge, if
So the
she's
only
using.
thing I would have to ask is there's no payments that have been shown on the schedule of arrearages. We would ask that the credits be given. We've already, so that we don't have to waste this court's time, already said that from this order, if you look at our pretrial.
Are you arguing now?
No, I just don't want to have to go into a whole bunch of testimony on this. But
Where's the May
Judge, we've
16?
already agreed that from this order forward, those amounts are reduced to judgment. Please look at my pretrial.
That is my understanding.
That is
I
my,
found
that
it.
is, so I don't think we need to go belabor it, Ms. Fuji. If we have to go, no, I just mean the orders, the judgments are what they are from before. Like I'm saying, I'm not re-arguing those. We filed September 29th of 2017, Your Honor. We're asking for the consideration to be from October 1st of 2017 forward. So I don't believe that you need anything other than what her schedules are with your orders, because the orders are what we went by, Judge. Okay, and then with the proper credits for the garnishment of $1,600 a month, it's $1,597 a month.
And Judge, and my client can testify what exactly the money that's being paid, what it's for, I can represent, because he does not know. It's the DA's office. Kroger won't take anything. It's just the DA's office, and it's child support and alimony, the combination of the two. The $50 towards arrears of the child support and alimony. When, in your order of May 16, 2018, you reduced, again, the things that were already reduced to judgment, and the payments that he, like the equalization, the $500 per month, all that's already reduced to judgment. So you can't ask for credit, as I claimed in the Kaladi case, not only stuff reduced to judgment, but retroactively when he owes of accrued payments.
And we're not asking for that, Judge. We're
Okay.
asking for the change
Then it won't
October
be-
1st.
then it won't-
October 1st would be the only change that we're asking for forward.
It won't be October 1st because some sums were already reduced to judgment as of May 2018, and he had
And that
owed
was
them.
already taken into account in my pretrial, like I said, Your Honor.
If I can just get a whole sentence out, what I meant, and what it says, judges, your order, and I did too, go off your order from May 16, 2018. 0 towards the equalization, 0 towards the arrearages, 0 towards gymnastics, 0 towards the arrearages. $50 a month, that's it for the child support arrearages. Still $50 a month. Still happening because those arrearages still aren't being paid off. Alimony arrearages and spousal support arrearages of $21,000, and my fees is $7,000. None of which, the only thing that's getting paid is garnishment 2.5 years later by the DA's office. And in your order, you said, Judge, that I will suspend the garnishment for going forward alimony. However, he will still have to pay towards arrearages. And that, I don't think, is what they are understanding. So the amount, $1,600, and it's right there in your order, you said, I am allowing, beginning June 1st, defendant's alimony obligation is temporarily stayed, but not modified, until the evidentiary hearing on whether he's willfully underemployed. Alimony arrearages may continue to be garnished. They were never garnished until right then, boom, right in June 1st. The DA's office is crediting it now towards the $21,000 or that he owes in arrearages off this report. So my client can tell you exactly how much she's received to date, and it's listed and identified in the pretrial memo. But I used your numbers, the court used, after May, after all the judgments, after reviewing all the orders. I think the argument counsel and I are having is a legal one, because you don't get to go back on things when there's a judgment, nor do you go back when it's already been accrued. So I think it's just a legal argument that I can brief if the court wants more of that, because I did it in my opening, not so much in my pretrial. But I think she's going to ask the court to recalculate and go retroactively back, as opposed to going forward should the court find it credible of a changed circumstance or not willfully underemployed.
And Your Honor, from the beginning, you will look at my pleadings from the beginning to now. They have not changed. It's been September 2017. I've been saying the same thing. We've litigated this stuff to death because she was going to get a whole bunch of stuff to tell us how horrible this person was. She can't find it because those are the only two letters, Your Honor. We don't have it in evidence, okay? We had to continue this because she got the same 2 letters that I got. If you remember that, that's what's been dragging this thing out.
I
okay?
object to her making comments about what I received. I've gotten, she doesn't know what I've received. She doesn't know.
Nothing's in evidence. Nothing's in evidence.
Right, exactly.
Okay?
Exactly.
So what we're going forward
and
is,
it's your
Honor,
burden.
that's $1,600. We're basically the DA's being a collection agency
It's your
for a judgment. That's what's happening here. There was only $1,000 that was owed for child support by the time we were here before. It's been paid 19 times over because it's almost $20,000 that he's paid. He has paid $19,857.07. That's what's been garnished to this date through the DA's office.
I'm going to object to testimony. Where's
Okay.
the audit?
Your Honor, that's what's been audited. That's what's been done, and she's going to have to testify to it too. But she's going if she says it's not, again, we'll just show
It's
the
your
DA's
burden
office.
to prove he's not
Today
willfully
is the day that I need the evidence. Where's the DA's audit?
Your Honor, we don't have a DA's audit. We did not get it in time. We did not get it.
Okay, proceed.
Okay, but for the record, he
No,
is
not proceed arguing. Proceed with questioning the
Please.
witness.
How much has been garnished from your check to this date?
About $20,000
Okay, and it comes out of your check.
out of my check.
Do you see it like on this exhibit from Exhibit 1? Oh, excuse me, Exhibit A. Actually, it would be Exhibit B.
It should be on here, 823. Yes.
And do you see it garnished out?
I see child support.
And how much has been taken to date?
800 and, oh, to date, 11,529. Oh,
Okay, and then last year? Is that when the other 10,000 was taken?
yes.
Well, I'm going to object to the form of the question. What do you mean last year? And what are you looking at?
Okay. When did they start garnishing your wages?
Okay,
Back
that's a
in
fair
May.
question.
Last year, May.
So in 2017, which would have been last year, did they also take about 10,000 out?
Yes,
I
they did.
object to the form of the question. I've seen nothing that's 10,000. I've seen nothing that it started in April.
I don't have any proof of when the garnishment
Exactly.
started, what they were garnishing
Exactly.
If I
You-
remember
you have-
correctly, it was back in May.
Okay, May. And do you know or not know where the money that is taken out of your check, where it specifically goes in the judgments?
No, I don't know the breakdowns. No,
Okay. But you know it's going to pay. And
I thought it was going to child support, and then the rest to alimony, which that's what I thought. Pay the child support
Okay.
first, and
So you understand that you have no child support arrears now.
no, I did not.
We don't have to
He
guess.
still does.
We don't have to guess. There's an audit somewhere.
Right,
We
and
need-
Judge, and
Okay, hang on.
I
Are
just-
you
I
only
have-
asking the court to do what the judgments are already been done? Are you
wait
asking
a
the
minute,
court-
she
I'm
withdrawing
only-
the question
yeah.
or the statement? Because when you make a statement, the child support's paid in full, when in fact it's not, if they don't have evidence, I just object and would like that stricken, Judge.
I just
Okay, sir, you don't need to speak right now. I need the documentation of what has been garnished from his wages and what it's been credited to. Okay?
Have you tried to get any information from the district attorney's office regarding this?
no, I have not. I went to child support, and they did not have that case in there, so there
Okay,
was.
so you tried
I
to.
did. I did.
When you said no, is that correct?
Oh
or
no,
not?
I don't know
You
where
said
the district
no.
attorney is. I went to the building itself
Which building did you go
on
to?
Flamingo and Burnham,
Okay,
and they did not have that case in there.
so you tried to do what?
So I was trying to find out what was going to what, and they didn't have it at that facility.
Okay.
They didn't have our case.
And did they tell you to go somewhere else?
They said it was probably in the court. So I just stopped there.
Okay. Now, as you sit here today, are you asking the court, you remember the order that we did and remember the pretrial we did?
Yes.
Are you asking that the court do what we asked in the pretrial?
I'm
Just
asking the
change
court.
child support.
Yeah, I'm asking them to change it as of October 1st, because we're not going to change the arrears. I understand that I owe that. So
Do you understand when a judgment is entered by the court that we are supposed to just accept?
Objection calls for
Yes, I do.
speculation.
I do apologize.
Go ahead, finish.
Yes, I do understand that now. I didn't before, so I do apologize for that. Like I said, there's a lot going on, so I apologize to you because I didn't know how it all worked. So
And are you asking the court to enforce the prior orders, which is the judgments, and then just change the child support from October 1st forward and to eliminate the alimony obligation? Is that correct?
that is correct.
Okay. Is it the same request that you had all the way back to September 29th of 2017?
Yes,
Okay.
but I felt that fell through. So yes,
Okay. And is it the same request that I filed on your behalf back in September
yes.
Of what year?
of 2017?
Thank you. I just want to make
Because he
the
was
record. I
2016.
want the record to be clear.
Correct, Your Honor. I'm sorry. He filed it in November of 2016, and I believe I might have said 17. I filed in September 29th of 2017, Your Honor. Okay. And then the order that we were going off of to get all of our judgments was the order that the judge entered herself this year on May 16th, 2018. Is that correct?
Yes,
Okay. And that's what we based our pretrial memo was on?
yes.
Okay. And I see that we have schedule of arrearages. Okay, and it shows in the garnishment that, in the schedule of alimony that you paid the first 4 months voluntarily.
Yes.
So you
until
did pay her without
I
a
paid
court
it,
order.
and without a court order until I ran out of money. I had no more money to give. I gave as much as I could. Even the 5th month, I gave, I believe, $300 or something like that, and that was it. The rest I had to make sure that I would be able to live and take care of the kids, and so.
So the first four, let's see, the first four was 1, 2, 3.
And not only that, at that time.
Wait a minute.
Look,
So this doesn't even start until the arrearages on the alimony doesn't even start until October 1st of 2016.
objection
Is that correct?
calls for speculation.
Yes.
Your Honor, the
We're
I'm
going to
looking
have
at the
these
document.
marked.
It has a date on it.
I just want she just said that child support arrears were paid. Your
No,
own
no,
pretrial
no.
memo.
This is alimony.
Arrears. I'm just going back. I'm just trying to follow your thought process. If you would like to argue this in close, I have no problem arguing it in close, but it's painful when he indicated he doesn't know. He just knows how much is taken
He
out.
said he paid 5 months of child support and alimony till he could not do it anymore because
And
of
it's
the painful
reflected in the schedule of arrears.
amount. No, it's not. The schedule of arrears doesn't start until October.
Counsel. Stop this back and forth bickering. I asked that the schedule of arrearages be made exhibits, and I asked that he testify as to the schedule of arrearages. Okay, that's very simple. I want the record to be clear. I know it's already part of the case file.
I just don't have a child support one. All I have is a schedule of arrearages for equalization payment filed May 8th, 2018 at 12:09. I have a schedule of arrearages filed May 7th at 4:37 for a schedule of arrearages for alimony.
All
I
right.
have one for the gymnastic payments that was scheduled May 8th, 2018 at 9:54, but I don't have a child support arrearage
So
one.
to help educate her on this, Your Honor, in your order of May 16, 2018, it said, on October 24, 2016, the court entered the order amending the order of May 26, blah, blah, blah. The court found a child support obligation from defendant to claim the amount of $697. It is undisputed that defendant owes child support arrears of $1,176. Plaintiff filed a verified schedule of arrears. Defendant does not dispute that acclaimed amount. That amount is already reduced to judgment against defendant. This is in the judge's order dated May 16th. It is in Don Lozano's pretrial memorandum on page 5. In lieu of receiving child support from Angela, we would like it to be applied to satisfy the child support arrear judgment of $1,176. She's
I
asking
agree with all that. I'm just saying
for
what's the schedule of
things.
arrearage?
What?
One at a time. She wasn't finished speaking. I don't hear what you're saying when she's still talking.
I think it is misleading to the court to try and criticize or say, I have filed numerous schedule of arrears throughout this time, back in January 2017, back in 2016, but ultimately this court had to do the arduous task after updated schedule of arrears and financial disclosure forms were done to make a decision, and you did so very well in that order from May 16, 2018, order after hearing, outlining and detailing and incorporating the schedule of arrears. Testimony as to Lupe was not disputed, and therefore additional sums, which were already reduced to evidence, were still reduced to judgment. Were reduced to judgment yet again. It's disingenuous to say, "Where's your schedule of arrears filed for child support?" We were at the hearing. We asked. A schedule of arrears had been filed. He did not dispute it. It's already reduced to judgment. So what is the issue? It is being garnished at $50 a month. That I don't know if you knew that, but it's not paid. So
The issue is a mistake right there in the pleading, Your Honor. It's very clear that you said $1,176. It's very clear that their schedule of arrears says $1,162. I was trying to clear up the discrepancy in the typo. I believe that yours is correct. I believe hers is not correct. So what?
Well,
It has to be cleared up.
There's a judgment
you have a
entered
judgment.
for child support arrears. Are they garnishing the base amount of monthly
Just
child
$50 a
Oh,
month.
just the
$50
arrearages.
for arrearages. Just $50. Because if you don't order, you ordered 500, but that was for an equalization payment. They will only do child support and alimony. So they only would take $50 in arrears. That's it. So $50.
Plus the current of $697. Again,
Correct.
That's what I just asked.
Correct.
yes, she's saying no, but she's giving $1,600 because it's going towards that. The way she's done these judgments is so confusing. The DA's office are not supposed to be collecting a judgment. They're supposed to only be collecting child support.
No, and they were.
And no, they're not. No, they're not, Your Honor. That's the problem, is they're trying to keep that $50 in to get the rest of the judgments in. They're trying to make the DA's office be a collection agency.
Well, if that's your issue,
And
argue
I said,
it.
okay, direct, no problem. Direct garnishment, we'll put it straight in our account, whatever we need to do. But again, it has nothing to do with child support when they're garnishing the rest of the judgment, which again we acknowledge in our pretrial.
I think my pretrial memo sets forth what the order from May 16th continues on, exactly how much being garnished, and what our prayer is for the future. I don't know how, when we don't, my client hasn't had the opportunity, Ms. Lozano's had several hours to educate herself, but I think this May order, if we go off the May order, he testifies how much is being taken away, what his understanding is that it's child support and alimony. When the court says, when Ms. Lozano says, the DA's office is not allowed to go back. Yes, they are. In this order, which was given to the DA's office, I'm assuming, it says you can continue to garnish for alimony arrearages. I'm going to stay it from June 1st. He doesn't have to pay that $900 anymore, and that's something we're asking for recouped. But they can continue to garnish for arrearages. If you have an issue, then that should be taken up with the DA's office. But my client is, how can you envision $80,000 or $68,000 worth of arrearages and trying to cut off zero going forward is my bigger question. If you're going to say the schedule of arrearages are wrong, go off the judge's order from May 16, 2018. I am fine with $50. I am fine.
And I am, Your Honor, but even your order doesn't match the schedule of arrearage. I'm telling you, there's a typo. I'm showing it to you. That's the schedule of
Proceed with your
arrearages.
questioning.
Okay. So, again, going forward, we don't have a separate schedule of arrearages, but this is a schedule of arrearages that was filed in January 2017, which he represents as the last one that's filed. Do you know if all that child support's been paid? Have you paid more than $1,000, $1,162?
There's no arrearages.
I-
Did you file the January 25th or the January
I paid.
26th schedule of arrears for
Hang
child
on.
support?
I have. I want to make sure we're on the same page. I
January
have January 25th, 2017 at 9/10/05.
And there's a January 26th schedule of arrears for child support.
There's another one.
Yeah, I filed like 10. Just look at
Again,
this.
Your Honor, if we're going to go off the order, I want to make sure we're going off the right order, because this one is not what's reflecting in yours, and those are the numbers we're going off of.
She knows it's arrearages, not monthly. She knows.
So do we have a separate one that I can go off, Your Honor, so I can question my client properly, because she's saying there's another one after this?
After which one?
She said, I only have the one from...
What are you looking for, child support
There's
arrearages?
the 25th, she says there's one on the 26th, Your Honor.
Are you looking for child support arrears?
Yeah, there's one the next day. It was amended. Let me get it for you, Ms. Lozano.
See, it's a spousal support arrears schedule. It's not a schedule for child support
I
arrears.
filed
But
a,
I'm reading,
But, Your Honor.
filed January 26, 2017.
Thank you.
Schedule of arrearages, child support.
thank you.
Do we have a number? Is it different than that number?
It says 1162.
That says 1162. Your judgment reduces it 1176. I'm just trying to get the numbers right, Judge, so we can be clear on all the numbers.
Well, is that with or without interest?
I don't know, Your Honor. I have...
None of them are with interest, Judge. I did not have the...
you have it on
form.
page 2, lines 25 through 27, into page 3, lines 1 through 4. If you'd like me to show it to you.
No, I have it.
Oh, okay.
I have it right here.
But it says it's undisputed that the child support arrearages is 1176 and your number is 1162, and I don't think he would even know what his child support arrearage number schedule was.
Then why are we
when he says
asking
he
the
agreed to
question?
it, I'm sure he agreed to the actual number.
Okay, so we're off $14.
Okay.
Is that what you're saying?
I'm not sure, Your Honor. I just would love to know where that number came from. Because if we're saying we're accepting your judgments and we're accepting the schedule of arrearage, we would be in, we'd have a little bit of problem on math.
And at this point, I would cite Aztec Mines and say, you know what I mean, Judge? Can't now bring up an agreement that was not presented for consideration. I'd also argue that no error, I got it, hang on. Pease v. Taylor, no error in either the admission or the exclusion of evidence, no error in defect of any rule or order in anything done or omitted by the court or by any party that's not substantive or does not substantively affect the rights of the parties. In this case, the schedule of arrears predated the two judgments afterwards and his acknowledgement of the judgment on the record contained in the order, and therefore it's moot.
Thank you.
Your Honor, we would just ask that the court look at that and see if that's been changing.
Same objection, Your Honor. I'd go with the latest one.
Sustained. Here, Frank, you can get this back to Ms. Lozano, please.
1176. I'm sorry, Your Honor. We had an interim order from the February 8th hearing that set it at your number, which is the
Use the year,
1176.
please. Use the year, please. Make the
I'm sorry,
record
I'm sorry.
clear. Make the record
Order
clear.
from your order from February 8th, 2017 took into account the payments and the legal interest collectible by any means. That's what you did at that point. And then you took the last payment he did. You asked for that payment, which was like $650, and then you got the 1176 number from it because it was at 1826. You took the $650 payment from there, so 1176 is how you got to your number. So I believe your number was correct. So I'm actually showing Ms. Fuji that she's wrong, $14 to the bad.
Are you
So we're saying
talking-
it's good. So this one should be higher.
Are you talking this February 2017?
Correct, but it's been incorporated into the 18 order, and the 18 order is correct.
So-
Your number, not the schedule of arrearage. Correct.
Okay.
I'm just trying to be good on all the numbers, Judge.
Your Honor, just to make a clear record, on February 8th, 2017, there was a motion he filed to review child support and obligations under this same changed circumstance, orders modifying everything. He was present with counsel, arguments regarding his employment, income, arrears, living arrangements, FDF, modification of alimony, and the Fernandez case, and fees. The court noted a wage assignment was granted for the bonus, which was signed in open court and returned. At that time, the court made findings. He made over $100,000 a year.
Your Honor, again, this
And
is
there
all
was-
stuff that's already been looked
Don't
at.
interrupt.
Do you wanna-
Don't interrupt.
Just making a record. And there were no grounds to modify. The court
Again,
further,
objection relevance.
because
It's a-
you made a
It's a matter
record.
of the record, and so it is relevant.
At that time, Your Honor, the schedule of arrears for child support and alimony were reduced to judgment at that time, carrying legal interest collectible by any means. Attorney fees were awarded for me, and I was to submit a brief pursuant to Brunzell analyzing the factors, which was done, and the order which was filed. And I'm reading from those minutes. So this is the order that is now, I guess they're having an issue with $50 a month.
No, Your Honor, what she's doing is she's trying to use the DA's office for collection agent. That's what she's doing.
I'd
She's
like
submitting
to
all
strike.
the orders and getting all of them
Take
done.
that up. Take that up with the DA's office.
Yeah.
Can I have that?
But Your Honor, do you have any problems with any of the schedule of arrearages as long as you get credit for all your payments?
No, as long as we go back to October 1st, hopefully,
Okay. And then from October 1st, what are you asking that the court do?
to remove child support and alimony and just get it right.
And you know you guys did as your child support obligation before pursuant to Murphy, so that you took your income and her income. Are you just asking that they do the same thing this time?
Yes.
Objection. Leading. Black's Foundation, if he knows what Murphy is.
Okay. And then do you know that Angela gets a raise every year?
Objection assumes facts,
Yes,
not
she
in
gets-
evidence.
Sustained. Foundation.
Yes. Can you tell me about how long were you married?
Close to 20 years, 19 years.
Did you know about her raise history and her work?
Yes,
What
she
was it?
gets $1,200 every year raise,
Okay.
automatic.
It's a cost of living.
Okay.
Cost of living.
And when did that always happen?
August, September.
So it would be right about now?
Yeah.
So if she has a financial disclosure form on file, she would need a new one?
Yes.
I have nothing further, Judge.
Thank you. No other questions.
Please step down.
I'd like to call Miss Angela.
Can you please raise your right hand? You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please be seated.
Can you state your full name for the record?
Angela K. Pellegrino,
And where do you live?
6741 Corrine Hills Court.
And what do you do for a living?
I am a first grade teacher with the Clark County School District.
At the time of trial in this matter, January, February, March 2016, did you have the same job?
Yes, ma'am.
Your income was approximately, at that time, $65,000. It is now like 68, almost 69,000. Did you get a raise?
No, we just get cost of living raises, and periodically the school district has taken away money, and then when they get more funding, we'll get it back. So, but I'm maxed out as a teacher. The $1,200 that he referred to was when I was a beginning teacher, and each year of teaching, you would get a $1,200 raise for more years in the district, but that subsided a long time ago because I've been teaching over 20 years now. On that scale, you maxed out at after 14 years.
Okay, so are
what
you
he's referring to
maxed
is-
out as a first grade teacher?
Yes.
Okay. Did you file a financial disclosure form since trial?
Yes.
Okay. During the trial, this court heard testimony as to Lupe's income.
Yes, ma'am.
Were tax returns, W-2s, and records from Kroger included?
Yes.
Were employment records received via subpoena duce tecum also admitted into evidence?
Yes.
Did that include stock dividend options, health saving plan documentation?
Objection, Your Honor.
And-
Anything that has to do with the stock dividend plan has already been dealt with. Move to strike.
Ms. Fuji.
It was a full question. It's a foundational question about what was admitted to evidence. So until she hears the question, it's leading up.
Move to
So
strike.
it's about-
Anything regarding a stock option was already dealt with.
Please state your entire question before you.
Thank you. Were his employment records in Kroger obtained via subpoena duce tecum admitted to evidence? Sorry. Did that include his dividends options, his health saving plan documentation, and proof of his Bank of America Merrill Lynch 401k,
Yes.
and his bonuses?
Yes.
What about his U.S. bank records?
Objection. Still same objection, Your Honor. This has all been litigated before. You kept me kept me in on this. Objection. Relevance.
Ms. Fuji.
Thank you. And fair enough, because I did it to her. But I'm laying the foundation. This court had the same documents as today that it had then, the only difference being that Lupe's been demoted. So it's a foundational question for a purpose that I wrote out for a purpose. So it's not so much to prove I'm not trying to relitigate, more or less trying to prove the documents that were admitted to evidence that the
objection.
court
All
utilized.
right, sustained. Let's move past that,
Okay.
please.
One of the reasons we're here today is regarding bonuses.
Yes.
Strike that. I'm going to move on. The schedule arrears that were filed at the time, back in May 2018, were those the amounts you had reflected, what you had received and how much was owed as of when?
Since the judgment that Judge Hughes filed in October of 2016.
So these were in addition
These were in addition to
what was already reduced to judgment by order of this court?
yes.
Objection, Your Honor. What I have is not from that time frame. So if there's another one, I need to know from that time, because she said she filed a whole bunch of them.
What is that?
So I need to know what she's
I
talking about
think
as far
they're
as
the
the
same ones I gave you.
We don't have anything from May of 2017. So if she has something from May of 2017, let me see. That's the one she's talking
Did
about.
you mean 2018?
I did, Your Honor.
Yes.
Thank you.
I see no payment.
To date, has Lupe paid anything that wasn't garnished?
No, I think there's a disconnect with his counsel in the of what I don't think he understood the order, or if she understands the order that Judge Hughes filed in October of 2016, because there were two arrearages payments. One was to be garnished, the $50, which was solely for child support.
And that's mentioned in the order by this court and decision in October 26, 2016.
Yes, ma'am. And then there was another arrearages payment that he had to willingly pay, which was $500 that went towards the equalization payment, the back spousal support, and that is a payment he has never made, and her order was filed in October of 2016. That is a payment that is never made, and we do have the schedule of arrears, and that's the $500 payment. And then he was also ordered...
That's why the equalization payment says $500. It doesn't.
Yes.
It doesn't go $29,288.40. It breaks it out.
Yes, that
$500
and then
a month.
That equalization, the $500 that Judge Hughes ordered him to pay has never been paid, and the arrearages also reflect Ivy's gymnastics, which he was court ordered since May of 2015 to pay half of her gymnastics and has never paid one penny. And you can see the equalization the arrearages that were filed in May that we filed showed that his portion since May of 2015 is over $17,000, and that was in May. And now, even though Judge Hughes, last time we were here in court, told him very sternly that you will follow my orders, he left the court and still didn't pay for her gymnastics for May, June, July, August. So now that number, his portion, has grown to over $19,000. And this is in the last 3 years, since May of 2015. His portion is over $19,000. So I have paid on my own close to $40,000, and that doesn't even reflect all the traveling I've done with her: Kentucky, Reno, San Jose, San Diego, Long Beach, all her choreography, her music for her floor routines. That's all money that I've put out that's not even listed in that. So his arrearages to date, and I have every invoice from the gym, everything's highlighted. I have copies for everybody who, if I'm allowed to pass them out. But his portion of her gymnastics is over $19,000 current.
Well, let's start with the gymnastics. For gymnastics amount was already reduced to judgment by Judge Hughes. You indicated.
Yes, and I did
And Your Honor,
me
objection,
finish.
as far as the gymnastics, we've already agreed and stipulated to the judgment, and we've
Okay.
agreed to go forward to pay for it.
And
And again, I don't exactly know, other than this garnishment, why he can't pay for it. We've agreed, stipulated, agreed to that. So wasting time on that just makes no sense.
Your
Objection,
Honor.
relevance.
If counsel's going to testify for him, I would ask you to please tell the court, why are you concerned that if counsel's stating correct, she agrees with the subjects reduced to court's indulgence? You saw a copy of our pre-trial memo we filed in this case?
Yes, ma'am.
In it, I listed and reiterated what Judge Hughes had reduced to judgment.
I did want to make a comment about Judge Hughes' May judgment that was filed, it stated in there, we filed a schedule of arrears in May that showed his portion was over 17,000, but then when the judgment came, your number was 14,000. So I didn't know if that was a typo or where that number came from, because he admitted that he owed the gymnastics, and our schedule of arrears was over 17,000, and there was no objection to that schedule of arrears. So there is a $3,000 discrepancy. So I don't know if you'll
Has he
accept
played?
our new.
I'm going. The amounts that are currently reduced to judgment by this court, and I'll start with the equalization payment, which was $25,814.94. The court can take judicial notice of that. How much have you been paid of the equalization payment? Just say. Do you know the amount?
Well, if part
Say
of his
the amount, if you know.
whatever I've received from his bonus that he was
Okay.
ordered to
So
give,
wasn't
yes.
didn't the court indicate that you would be paid that equalization payment from his bonuses, right?
Oh, yes, he knew that from the
All
beginning.
right, and did you get that bonus?
Only this year, not in the previous years.
Okay.
Every time we came to court, he claimed to have spent it.
All right, and this was the $2,609.06. You only got the $1,300, and then the invoices, I think that Ms. Lozano was trying to show you receipts. That was him paying you back the other $1,300, so you got the total $2,600
Yes, ma'am.
bonus. So that equalization payment of $25,814 now is only $23,205.
Yes, ma'am.
And how much of that is being paid via garnishment?
0.
Okay. And how much has he paid of his own?
0.
Okay. Have you added interest, prejudgment interest to that amount?
I haven't. I know that it is 2% that accrues, but I
Okay.
haven't done the math on that.
Spousal support arrears was reduced to judgment $27,700. How much of that has been garnished?
0.
Didn't you receive, as of June 2018, when the judge stopped it, didn't the DA start doing it towards
And
arrears?
the 900 would be applied, but I believe,
Yeah.
according to Judge Hughes' judgment that came out in May, depending on what is concluded here today, whether that would be fully applied or not.
No, I don't want you to guess or speculate. The judge already ordered. Alimony arrearages may continue to be garnished. So arrearages, those arrearages of $27,700 were not garnished until June 1st, 2018, when the court stated in this order, beginning June 1st, 2018, defendant's alimony obligation is temporary stayed until the evidentiary hearing on whether or not he's willfully underemployed. Alimony arrearages may continue to be garnished. So up and until then, none of them were being garnished,
Nothing.
correct? So June, July, August, 3 months at $900 is $2,700.
Yes, ma'am.
All right. So that you've been received via garnishment.
Yes.
Have you received any sums from him
No.
directly? All right. Child support arrears, $1,176 was reduced to judgment. When did arrearages get garnished all along, or did that too just start in June?
The $50 has been getting garnished.
Okay. I have June, July, and August. $150 have been garnished. Has more?
Every month, the $50 is being garnished.
Okay,
along
and that
with-
is since starting when? Because my pretrial memo is incorrect, Judge.
Since his wages have been garnished.
When did that begin? He said a different date than you told me.
The Kroger was garnished.
Just listen, don't
the
overthink it.
DA's, I filed with the DA's office August of last year.
August 2017.
At the Flamingo office.
Okay, August 2017. And if able, can you try, I don't know if they're going to give it to you because it's his paycheck. Can they give you to date an audit of how much has been received via garnishment?
And anything, I've called Kroger and I've called other places, and they're his documents, so no, I'm unsuccessful in.
Maybe I could help you with that. All right. Okay. Gymnastics, reduced to judgment. I think I added more. 19,140.19.
Yes, and I have every.
What was the amount reduced to judgment and the amount that's increased? Let's see the court's order.
That was the $14,000 figure, but that didn't correlate with our schedule of arrearages that.
So let's
was
clean
filed.
that up now.
Yes. And then all the payments since then.
Has he made any payments towards any of the gymnastics arrearages?
No, or any current. No
No.
arrearages.
Is it no? And has any
No.
been garnished?
No.
Okay. And he was ordered to continue to pay half of her gymnastic expenses because of the competitive level she's at?
Yes.
And has he done any of those payments?
No.
Is this a gym that you could put a credit card? Can you give a credit card, or is there a monthly charge?
He could pay online. There are numerous ways he could pay.
Reduced to judgment was $14,199.10 as of May 2018. But was there a prior amount reduced to judgment by this court that was larger?
That I would not know that.
So where do you come up with the number being 19,000?
Our schedule of arrearages
I have
shows
a
a
copy.
$17,000 figure.
7,094.34. So your schedule of arrears started from the court order of May 2015?
Yes.
So you don't know what the discrepancy is between the 17 and 14,000?
I don't, because Judge Hughes, her decision showed that he admitted to owing $14,000, but our schedule of arrears that was filed for that time showed $17,000, so I didn't know, and he's never paid anything, and he didn't object to that schedule of arrears when we were here in court last time, so I just didn't know where Judge Hughes had gotten that.
So just so you
that
can
might have
now-
been a previous.
Now you will need to
And I have every
testify
invoice since May of
to your
2015.
schedule of arrears. Your Honor, if I may approach, I'm going to show you an unfiled copy, but this is your second schedule of arrears for Ivy's Gymnastics that was filed on or around May 2018. It's very short. It comes up with annual numbers for the year. How do you come up with that amount?
From invoices from the gym.
Is there a monthly fee or amount that was set by the court for monthly or?
For, yes, depending on what her tuition has been, and it changes yearly. And it currently her competitive season goes July 1st to July 1st. So her tuition just went up to $585 a month. And I have documentation to show all of that. And then in addition to that are frequent payments for all of her competitions and all of her stuff, and I have those payment schedules as well. So there's her monthly tuition that he was ordered to pay half of, and then he was ordered to pay half of any additional costs.
Okay.
That's the way Judge
So
Hughes
the
ordered
the tuition amounts, these schedules, and the invoices for Flip Me Gymnastics, they were produced at trial.
Oh, yes.
And you prepared something to supplement since that time, so we have a current, because this was an ongoing obligation.
Yes.
Okay. Let me approach. And when did you prepare this?
Last week.
And what did you prepare?
A document showing yearly what has been paid in total and dividing
By
it
you?
by me. I've paid it all, and then dividing it by half, showing his obligation, and then I have all the invoices from the gym, and then also on the table I have her new payment schedule so that Judge Hughes could see that her gymnastics has went up to $585 a month.
If I may approach her.
Yes.
Do you recognize this document?
Yes.
What is that?
This is the document that I prepared for court today.
It's looks like an Excel or summary. It's for 2015, 2016, 2017. Tell us what 2018 is through August.
Through August of 2018, the amount that has been paid is $6,132.48. That's what I have paid. So his amount is $3,066.24. That's just for 2018 so far.
So your schedule of arrears goes through May 2018, because that's when we filed them. You're saying from that time until now, there was additional sums, May, June, July, August, for 3 more months?
Yes, and additional payments made. So now the new figure is $19,397.83. That is the total owed by Mr. Jimenez since Judge Hughes' order that was put into place May of 2015 when he was ordered to pay half of her gymnastics.
And to support your spreadsheet that you created, what did you provide?
Ms. Fuji, these are invoices from the gym. I didn't prepare these. These are documents that I got from them and highlighted each amount showing everything that I've paid. I prepared the front document summarizing all of their documents. So these are all of the invoices from the gym showing everything that I've paid since May.
2015.
And Your Honor, we've already, like we said, in our document, and we actually have it on page 5, lines 26, saying $14,199.10 is accept. Again, all these things have been accepted. I'm wondering why we're going over the past stuff.
She's filed an updated schedule. Or you've not filed it. I have not seen it.
No, not since May 2018. Not in the last 3 months. So I'm having her testify to the additional.
That's what she's doing.
Yeah, that's exactly what I'm
And we've
doing.
already said that we would take care of half of that forward. Again, we just are under a
I don't
huge
think you
assumption.
have the information.
Yeah,
This is new information.
this is new. Since May, so we've got June, July, August, 3 more months.
I understand, and he said that we've put on the record clearly, Your Honor. We accepted the judgment amount, and we said that from this point forward, we would do a direct straight to the gym, straight to them through a.
Okay, so since the
assignment,
judgment, there's
absolutely.
been 3 more months, and you don't have that
Yes.
information.
Oh, I understand, but we've already
Okay.
agreed to it. I'm just saying, just for time's sake, we've already agreed to that, Judge.
Okay,
And then-
you've agreed that he owes it, but
How's
And
it
we'll
gonna?
pay it, absolutely,
How?
absolutely.
How much?
how is it going to get paid?
Well, if this garnishment stops, then we can go ahead and pay a lot of these things. We can pay it towards each one of them. But right now, it's going towards everything. And it's half of his income is being taken away.
How do I know that it's going towards everything?
And I can test. I believe he testified it was just child support and alimony. I'll ask her, and they can take
he
that
said
evidence.
He couldn't get that, and he tried to get that information and
I don't
couldn't
have
get
any
that
evidence
information.
about that.
They're
I
still
need-
garnishing at that $15.97.
Can you explain? I want to finish this thought up. Did you? The statements prior have already been submitted, but do you have a statement or an invoice for the current 2018?
Yes, it's in this packet.
And it's through what date?
Through May, it was last week that I had the gym owners send me
So this is up and until what date?
till, the statement date is August 14th.
Okay, and include membership or the meet fee for August 15th. So this shows you, and this is what you used for your current spread?
Yes.
Okay, all right. And you said our schedule arrears, that amount reflected, that's a little higher by $3,000, is what you have as documentation.
In here, yes.
I'm going to, if I can, mark this as Exhibit A and move to admit an evidence. I don't think they have an issue with it. I'll give you an extra.
We don't have it. What is this?
It would be one exhibit.
My apologies, I'm playing with you. One. All right, so what,
And Your Honor, again, we would like to make sure that it's clear what the order was. It's supposed to be for gymnastics fees. It's not supposed to be for every other fee you can put on a card at a gym. Okay, so I want to make sure it's very clear. You had a very clear order before that was for her instruction, and it's not for other stuff. I know at a gym, because I was a gymnast, you can put everything on there. You can put meat, you can put travel, you can put snacks, you can put your clothing, you can put anything on there. Okay? So I'm saying, if it's gymnastics fees that you have ordered, we absolutely agree with them. I just want to make sure that's clear. I just got this. We'll have to go through it, but we totally stipulate to that $14,199.10 that you had before, 10 cents that you had before. This we just would have to look at because you can add other stuff to a gym membership and other stuff on there because we used to do it, okay? And you add other things on there. You were very specific. It was
either
for
object
those
or you
fees.
don't. You either object or you don't.
For what you ordered, Judge, we don't object. For other additional stuff, we object.
So, Angela, no, please, listen. Don't listen.
Yeah, and everything was
Don't
supposed to be produced, Your Honor. Again, we got nothing.
Angela, before I admitted that, is it admitted into evidence then? They don't
Your Honor,
object?
again, I would ask that we move on with relevance. We've already said that regarding the gymnastics.
I'm moving to admit
We will
that.
pay for half of the stuff that was ordered, like we said
You have an
before.
objection.
No objection.
It's
Thank you.
admitted.
Is there a credit card that Lupe could leave at the gym for the monthly fees or payment?
Yeah,
Again, Your Honor, no, same objection. We're going on to the same thing. We've already said, let's do it.
yes, ma'am. He could pay in person
Your
at
Honor,
the
can I
desk.
get a ruling
or-
on this? Because we're going to go into
Overruled.
this.
Go ahead.
Yes, he could pay in person at the gym through cash, check. He could pay with credit card. He could pay online with credit card.
Does he have credit cards? When you were
I-
divorced, did he have credit cards?
Yes, ma'am.
Okay.
And Ms. Fuji, I would like to also state that I brought with me documents from the gym showing what her monthly tuition is and all of the additional costs, so that Your Honor doesn't think
do you know
I'm
what the-
putting flights or travel costs onto her account, which would not be
No,
possible.
Your Honor, I was just talking about like black leggings and T-shirts and all the clothing and all the other stuff that you didn't order for him to pay. We're trying to get out from underneath
I've never seen a
huge,
gymnast wear
huge
black
judgment.
leggings.
Okay.
Okay,
Is that an
I'm saying the fees, not other stuff, and I was very clear on that. And I told you clothing was on there, and I looked at it, and there it is.
She has to wear
Don't-
competitively
please,
as hard.
listen.
And
Angela,
those
yes.
Angela, don't-
those
don't-
are
please answer my
ordered.
question.
She's measured and ordered.
Listen, your attorney is trying
Angela,
to direct
please,
you.
Please do not feed into.
Okay.
Please. The gym gives a schedule of how much has to be paid.
In addition to the monthly tuition, yes, and I've provided
What is
that.
the monthly tuition?
The monthly tuition is $585 a
And
month.
do you have proof that the monthly tuition is $585?
Those are documents from the gym, yes.
May I approach?
And then the other
Wait.
Okay.
Please. Do you recognize these documents?
Yes, ma'am.
What are they?
These are documents that were taken
Your
from.
Honor, you were very clear in your pretrial order that we were supposed to have all this stuff by the time of trial. We don't have it. You ordered it to be done 10 days beforehand. I object to anything, very specifically.
Sustained.
Thank you. I don't want any of this.
I
Here,
haven't
no.
moved to admit it.
Object, Your Honor. And I ask that you, again, she's already sustained it.
I don't have this information.
That's fine. I just said, do you have any, does the gym give you documentation that evidence how much you pay a month for gym dues?
Yes.
And how much do you pay a month for gym dues?
$585 a month.
And that's per month, and is that, and there's a form, information and schedule that's given to you guys as parents?
Yes.
Okay. Would you recognize that document if you saw it?
Yes.
And I don't think he disputes the.
Objection, Your Honor, to all the documents she's trying to get in when she could have gotten this done before.
Sustained.
It doesn't matter. Has he paid any of the $585 a month?
No.
What was it last year, the monthly?
$565.
Okay. Did he pay it then?
No.
When he made $120,000.
Your Honor, again, still, objection. Your Honor, please, can I get a ruling? She's still going into belaboring these stuff that we already said we're going to pay.
I've sustained your objection.
And she's continuing to go. Could we please get her to move on?
She's asked a new question. How much was
No,
it
she's
last year?
continuing to ask it.
Right.
She said, how much was it last year and how much is it this year?
No, she was trying to get an income of about how much he was making.
That's what you're objecting to?
No, Your Honor. What she's doing is she's continuing to go into an area that we've already said that we agree to the number that you have. She has just given us sheets, let me see it, that has return check fees on it. It has bank service fees on it. It has a special event for the gym that she put on it as well. She put on clothing, leggings, T-shirts, another T-shirt. Again, a lot of stuff that is not, and that's what she's giving to us as gym fees.
This is the new one?
This is the new one.
I don't have it.
Again, Your Honor.
It's
What she submitted as
I know
far
it's
as
been
what,
admitted, but I don't have
Your
it.
Honor, what she has said is gym fees are not gym fees, and that's what was ordered by this
you
court.
can cross-examine her.
Okay, I just want to make sure it's
You
very clear.
stipulated that it be admitted into evidence. I haven't even seen it, so you
I
can
haven't-
cross-examine her.
I haven't stipulated to admit anything into evidence, especially this.
I thought you did.
No, 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 no.
You did.
I objected to it.
Me too.
I was objecting.
She did object?
Objecting,
Oh, I'm
yes.
sorry.
This is created.
And she admitted.
This is hearsay. This is created for trial. She said she created it today.
I made a mistake. I thought you stipulated. The
Objection.
clerk has corrected me, so it is not in evidence, and I'm not hearing any testimony about new gym fees.
But there's an order for, right now, for him to pay half her gymnastics, correct?
Yes.
All right, and how much is that?
$585 a month.
And you have documentation that support that amount, that you didn't just make it up, right?
Correct.
Did you bring it with you here today?
Yes.
Would you recognize it if you saw it?
Yes.
And Your Honor, I'd like to approach and give her a copy of the fees schedule, because it is an ongoing obligation for which the defendant was
That's
ordered
not
to
why
pay.
we're here today. So
Okay.
no, you had to
And Your
produce
Honor,
that
we have no
already.
problems with $585. What I have a problem with is $35 for bank fees and all these other
I think
fees.
I've heard it like 5
Yeah,
times.
I have no problem with
So the
$585.
record is clear, and I'm not allowing her to introduce a new schedule of arrearages at this late date.
It's not a new schedule of arrears. That's fine, Judge. It's just the new amount has changed, I believe, by $15 from what it was.
And we agreed to that
Back when
$14,000
your
number in your
orders-
order, Judge.
How much is being garnished, or how much are you receiving from the garnishment?
$50 towards child support arrearages. The $597 of child support. And the $900.
Of alimony.
Yes.
And this began when? Approximately August 2017?
From the DA's office,
Okay.
yes.
And if I add that up, that's approximately $19,200 that have been paid towards the amounts that are already reduced to judgment.
Yes.
Can you explain to the court why, if he is not ordered to continue to pay child support, what amount do you need going forward?
Objection, Your Honor. Cause for legal conclusion. I think the law tells us what's going on. She doesn't say what she needs for child support.
Is that an objection?
Objection, Your Honor. And calls for a legal conclusion.
And it does not. It's
It
What's
does.
your
She's
question
asking what
again?
amount of child support she needs.
What was your question again, please?
I'm testifying as to need, Judge. Her need. His ability to pay, her need for ongoing care.
For
For
child
ongoing
support
care.
or
For
spousal
everything.
support?
For spousal and child support. If he were to not pay child support or not pay future, what would you need? Because right now he's paying $1,600
Yes,
a month.
I would need $1,600 to be able to survive because that's what I've been able to survive with currently.
Okay. The alimony order in this case was what? Do you recall?
$900 a
For
month.
how long?
For half of our marriage, which was,
Was it $900 for 72 months or 5 years, and then it went up?
and then it went up to $1,100, yes,
For how long?
for the remainder,
36 months?
yes.
Why are you asking that it be garnished?
Because Mr. Jimenez will not willingly pay for anything which has been evidenced over the last 3+ years.
What if district attorney's office will not garnish for things other than child support or alimony? Where would you have to seek the garnishment from, Kroger or Smith's?
If they would garnish, I
In the
don't
past,
know.
have you had difficulty with Kroger garnishing?
Yes.
As you sit here, do you know if Kroger received the order for 100% of his bonus?
Oh, they absolutely received the order.
Objection, Your Honor. Calls for speculation. She doesn't work at Kroger. She doesn't work at Smith's.
You can cross-examine her. Overruled.
Exactly. What attempts have you made to get the other outstanding arrearages, the judgments like gymnastics and the
I
equalization
did
payment?
contact a collection attorney, Robert Qualey, and I have not hired him or...
You'd have to pay money.
I would,
Okay.
yeah.
Did you have an opportunity to review the records from Kroger that Lupe has admitted into evidence that he claims supports his inability to pay the court-mandated support?
Yes.
The entire 20 years of marriage, did Lupe ever have reprimands at work?
Not to that degree. He periodically over 20 years might get a write-up, but nothing serious at all.
In the 20 years of marriage, had he ever received a demotion?
No. Or threat of a demotion.
According to the records that have been admitted into evidence, one of the causes for the demotion is for his failure to walk the store and to hold meetings with his staff weekly. Throughout your 20 years of marriage, have you seen have you seen any evidence of Lupe being unable to walk?
No.
How about to speak to people?
No.
What about depression?
Never.
Any indication that he needed psychiatric assistance?
Not at all.
Did he ever have any physical or medical or mental issues during the marriage which required hospitalization?
No.
From the date of the amended decree of October 26, 2017 to today, do you know of any physical or medical or mental issues of Lupe?
No.
You still do the exchanges with the girls?
Yes.
Okay. And do you know if he's ever been involved in any accidents since that order
None that I'm aware
that
of.
would prohibit his ability to do his job? Do you know if he has a therapist or counselor or takes psychotropic medication?
No.
Alimony initially was awarded in this case, temporary spousal, was ordered in June 2015. Do you recall the amount?
$1,800.
He was ordered to pay $1,800 a month. Did Lupe seek a reduction?
Yes, he did.
And was that granted?
Yes, it was.
And did he pay it?
For a couple months and then stopped.
Did your schedule of arrears that you filed in this case adequately depict what he was ultimately ordered to pay?
Yes.
All right. Do all the schedule of arrears that have been filed in this case adequately depict what was owed at that time?
Yes.
Supplemented by your testimony today. Any of those alimony arrearages were not paid on and before the judge made the temporary suspension. Have you compared Lupe's financial disclosure form today? Well, strike that. It talked about you being tapped out, yet you still receive a cost of living increase. Does that happen forever for you?
As all of us know that live in Clark County, that teachers are always getting pay cuts, or we're always fighting to try to get our cost of living raises that most jobs are given.
Do you know if is that a guarantee?
No,
Okay.
never.
You said you need $1,600 because you were counting on it. Why do you need the ongoing support obligation?
Just to be able to support my children and myself.
Have your expenses, I've only heard of, strike that. Health insurance, at the time of trial, was there, or subsequent to there too, was there discussions about health insurance?
Yes.
And can you refresh the court's recollection as to that?
That because Kroger's health insurance was much more affordable, he would carry the children.
And how much was your understanding?
It was roughly $25 a child.
To date, approximately $19,200 have been paid towards the total amount of arrearages, which I listed in the court's order of approximately $68,000. That does not include, am I wrong?
Yeah, I would just want to know where that figure comes from, where 19,000 in arrearages comes from.
No, 19,000 payments were made towards, oh, strike that, you're right. The $19,200 that was been garnished from his account was not all for arrearages.
No, that was his court-ordered child support and his court-ordered alimony payments. Only since June, the new judge's orders has that $900 been applied towards arrearages. Before that, that was just
What he still owes you to live on, right?
Yes.
Okay.
Yes.
How much do you owe me? How much is my lien reduced to judgment?
It's over 16, 17,000. I
$14,948.23.
okay.
How much of that have you been able to pay?
None.
Do you need this money in order to pay your attorney?
Absolutely.
Was that equal? Well, strike that. Of the $19,200 that was garnished, you said only since June, the court's order of June, beginning of June 2018, the order from the May 2008 to begin June 1st. That is the only time when money went towards arrearages, and that was $900 for 3 months.
Yes, ma'am.
$2,700. What about the $50? You said you've been getting that all along.
The $50 is towards the child support arrearages.
So even though this says $697, they were only garnishing $597?
$597 was child support, and then $50 was towards child support arrearages.
I'm just saying the order from May 2016 says $697
It's $597.
for 2 children.
Yes.
So if I take 50 times 12 for the court's indulgence. $600. So if you were paying $50 of arrearage since August 2017, plus the $2,700, that's $600. So that's $3,300. $3,300 towards the arrears of approximately $68,000 that's already been reduced to judgment.
Yes.
Okay. Should the court find the demotion was valid and permanent, you're requesting that amount continue towards arrearages?
Yes, ma'am.
Is that your prayer today? Okay. One other question. I'm done. Before filing any motions or coming to court to seek contempt, do you know if there were attempts made by and between your counsel to try and keep costs down?
Yes.
Does Sierra, your oldest daughter, she no longer lives with you?
No.
Okay. And does Lupe participate? I understand Ivy's extremely competitive at a very high level. Does Lupe go to her matches?
He has not attended one since I filed for divorce in 2014.
Right now, do you bear all the cost of transportation of Ivy to her leagues?
Yes.
And were you aware that he was earning additional income as a Lyft driver?
I had no
That he
idea.
that he failed to tell. All right. I have no other questions, Your Honor.
Okay. Cross-examination.
Just a couple questions. I know that the court entered some temporary orders, and I know this was all before me, so you're going to have to kind of educate me, and just be patient, okay?
Okay.
Is that my understanding was there was $2,300 that had to be paid, and he was paying it. He did 5 payments before anything went south of any of the court's orders. You're saying no payments were ever made without a garnishment, so you didn't get any payments beforehand?
When the temporary orders
That's what I'm saying.
first
The court says, has he ever paid any of the orders that the court said?
Let her finish.
So from the temporary orders, it would have been spousal and child support, correct?
he did initially for a few months make payments.
So when he said he paid for 5 months and then he could not afford it anymore, and he paid $300 of your spousal for the 5th month, is that about right? Was he right?
I would have to look back at all of my records because I am pretty detailed, but that could be possible.
Okay, so he could have paid you $900 a month for 4 months, and then the 3 months, the $300 for the 5th month, as he said.
And this is all dating back to 2015.
Okay. So
and
this
then
is, because I was asking if any of the orders were there.
yeah, then he stopped. So he picked and chose initially when the orders were placed what he would and wouldn't pay. So
Okay,
initially he
by
chose
saying
a
that he
couple.
didn't-
Let her finish.
Initially, he chose a couple things to pay, never paid gym, and then spousal tapered off, and then he was paying just child support. Even when the new divorce orders were put into place in October of 2016, he was still paying a lesser amount, even though she ordered him new child support. That's how the arrearages came about, is because child support
No, ma'am,
was
no, what I was asking is, you said he never paid on any of the orders, and you also added the phrase, not one penny.
of gymnastics. Of gymnastics.
Oh, only of gymnastics.
Of gymnastics,
Okay.
even though he was court ordered.
So
he
even though
never
he's paying
paid.
$2,300 a month, you're saying there's not one
Listen,
penny.
I didn't
object
put the
to-
order. I didn't put the temporary orders in place. Those were Judge Hughes' orders.
And I'm
so
asking,
yeah,
did he pay any monies voluntarily? You answered to your client, to your counsel, not one penny.
of gymnastics.
Okay, and you also said never paid any of the orders
Of
voluntarily.
gymnastics since he
No,
stopped
no,
payment.
on any of the orders. So it's true that he has paid on some of the orders that were here, like he testified to, that he could afford.
Over 3 years ago, yes.
Okay, well, the judge entered the order. I'm just confused. Okay, just help me. Okay,
Oh,
the
you
judge
know,
entered the order in May of
it's
2016.
argumentative. I think the point is made. So my objection is, it's really irrelevant about a temporary order, and that was combined. If you want to know, was combined alimony and child support. He only did it 3 months. Filed a motion, got it reduced, and then didn't pay that amount. So I'd ask that if you're going to talk
Your
about
Honor, I'm
orders,
asking you about her orders.
if
You
you're
say no.
It's not. If it's a temporary order that's been superseded
objection is relevant.
by a yes. By,
Sustained.
thank you.
Yeah, if I could clarify.
No.
Okay.
No.
It's sustained, so it means you don't answer.
Okay. I'm sorry.
Okay.
Just let's get it done.
I know this has not gotten in, and you have this whole gym thing that you do, right? You do it all the time, right?
It's already in.
As I stated before, I did not prepare that document.
I mean, just the document itself.
I
It'll
prepared
show-
I prepared the cover sheet.
Okay.
This is
I'm asking
from
a
the
question.
gym.
I'm asking a question. So besides the it should be 525, then it became 565, and now it's 585 for the gymnastics for your daughter, who's like Olympic material, correct? She's
That's
really good.
only monthly tuition, and
Okay.
according to Judge Hughes' orders, any additional costs accrued through her competitions, meet fees, everything he is to be paying half of. And I have that schedule, if you would let me show you, that for the competition year, starting July 1st, 2018 to July 1st, 2019, there will be $3,097 of additional costs, and I have the layout and payment schedule from the gym. So in addition to her $585 a month, there's an additional $3,000 a month. So for a year's total, her gym comes out to be around $10,000. So when you just throw out the $585 number, that's just one component of her competitions. And I'm not even asking for him to contribute to her travel costs. I'll take her. But as far as her competitions and her monthly tuition, that is only fair, and that is what was ordered by Judge Hughes.
But you wouldn't be asking for clothing, extra stuff at the gym, open gym time. You wouldn't be asking.
Those are
wait, I'm not done.
Okay.
And return of bank service fees, return check fees. You wouldn't be asking for any of that, correct?
Open gym. That if she needs additional training, then she will go to open gym and train for an additional hour or two.
Does she get a discount because she works there? I'm just seeing discounts on here.
Because she helps.
Because she helps out. And you help out over there. Do you get a discount?
I don't get a discount at all.
So there's no 10% discount FFS clinics 321 that you get a discount off your bill because of it?
Sometimes if I pay early, which because I'm the only one paying, I try to pay early, they will give a discount if you can sign a contract early or make payments early.
And then you're not asking for the clothing and the other stuff that has nothing to do with it,
The
right?
clothing, she is a competitive gymnast. She's not doing flips without clothes on, so she would have leotards. And when they go to state meet, the entire team gets matching T-shirts. They get those aren't things. I'm not charging things to her account. I can't go shopping and bring in things and charge to her account. These are things that the team requires. I can't put anything on her account. These are charges and team fees. So I'm not.
So what's flyaway / free hip? What's that?
That's a flyaway is a skill that she does off of bars,
make-
and a free hip is a skill that she does off of bars.
I'll just make the objection for relevance. It is what it is. He had 6 months to set aside the order. If they're going to try and redo it for the future, let him bring another motion. But
Again, Your Honor, we have no problem with the 585.
I don't care what they have a problem with. It's
I
the
would
order.
love to be able to
worry.
show the addition, which he has
Doesn't
access
matter.
to
Just
at the
Angela-
gym.
To litigate those fees.
Angela,
Right.
stop.
All right, so we're going to be in recess for 45 minutes
Well,
for a
Your
lunch
Honor, I
break.
believe I'm done. If you want to go ahead and let me just finish. I just got a couple more questions we can finish. That's okay?
You have redirect.
No, not really.
Okay.
I mean,
Okay. Do you believe? Didn't this happen in 2014 with this same thing with Lupe, where he had the 30-day notice and he got in trouble and had to go through all the?
Not that I'm aware of.
So you had no idea about it.
no.
No.
At the time this happened, did your daughter actually sign out of ASU and he had a lot of problems because she signed out of a school at the same time?
The
that you started?
objection,
I'm
relevancy.
asking.
That her
Oh,
college-
stop! You've got to listen.
Okay.
Did she withdraw
Objection.
from college the same time that you filed for divorce?
Objection, relevancy, and I think you're talking about 2014 as to the oldest daughter. What's the
I had
relevancy?
nothing to say about 2014. I'm talking about what's going on with this. Did she, at the
No,
time
I
that
just-
you filed for divorce,
I made
did
an
she withdraw from
objection,
ASU?
and I'm
Okay, and she objected, and the
Relevancy.
relevance, and the relevancy
because it's an
is-
adult daughter, not of this marriage, and I don't understand the relevancy at all.
Okay. Do you agree there was
No,
some
no, no.
stress at the time?
Relevancy. Are you responding to me?
No, Your Honor. I need to know relevancy because, again, I need to know what he was going through at this time, and the court needs to know what he was going through at this time as far as good faith.
In 2014?
No. This is a 2016, 15 when she served him with the divorce papers. It was at the same time that the daughter, who is a 22-year-old daughter,
But
their
don't
daughter,
testify. Don't testify. Don't
okay,
testify.
withdrew. Okay, so I'm saying I'm trying to get to the time of him.
No, she's trying to testify and put some facts in evidence because no one said anything about
I
their
need to know
daughter
also what you need to know. She said she didn't know about his prior problems at work.
being
That's what she said.
in or out
Okay,
of
you're on.
school.
You said. Let's stick to that. You said he had been written up before when you talked to her before. Okay, but he didn't have any kind of problems like this. When I can tell you in 2014 he had the same problem.
Objection assumes facts not in evidence. We don't have anything
So you
from
would have no
2014.
idea.
I don't know about that.
Do you believe he makes less money because he wants to pay you less money?
I truly believe that.
Do you believe he took a demotion for this?
Let her finish.
When you weren't his counsel during our trial, he admitted in court that he told me he would never pay me, and I believe he would go to any length to not pay me. So yes, I do believe that.
During your marriage, did you guys make comparative incomes?
In the earlier years, yes, when we were both new in our careers, and yeah, it was a 20-year marriage. Of course, at times we made similar, but not towards the end, no. He definitely had much more earning capability than me and was earning much more than me.
We only had 1 year where he earned over $100,000. Was there another year?
Objection assumes facts not in
He
evidence.
testified to it. Your Honor, please ruling.
I'm sustaining the objection. You have
Thank you.
5 minutes
Okay.
to wrap this up.
Did he ever make over $100,000 except for one time, which was 2015?
Leading.
That I don't know. I'd have to look back at all the records.
Okay, and you said you were a meticulous record keeper, correct?
For everything that he owes me, yes.
Okay. Did you
This
help
has
do the
been-
tax returns too and your family? You got that together to get it to when you were married? You said 20 years.
Did I restate
Did
that,
you,
please?
when you in their 20-year marriage, did you get the stuff together? He said you were the one that got everything together, like you said. So you were the one that like managed it. So did
So
you get all the
here's the
stuff
thing.
together to the tax?
I never said that I.
There's an objection.
There's an objection. Again, I think counsel thinks if she states it, it makes it fact or
No,
it makes
no,
it true. There was never any testimony today
Lack
that
of foundation?
she prepares. Yes.
Lack
no,
of
no.
foundation sustained.
Just that she's meticulous. Are you meticulous with paperwork?
In arrearages paperwork, according to this case that I am involved in, yes.
Did you help do the tax returns when you were together?
No.
Okay, so you had no idea what he made and what you made.
I had an idea, but I, in no way, shape, or form, helped prepare them. Did I submit my W-2s to the person that was preparing them? Yes.
So you made similar incomes up until the last 3 years?
Not more than that. More than that.
How many more?
I'm not. I don't have a photographic memory. Don't remember my tax returns from 2012, 13.
There's 2 more questions, Rena. Do you remember his work habits when he was living with you together as a
Yes.
spouse? Did he work? Did he go to work? And like
Yes.
he said he never called in.
Yes, he went from a bagger to the store manager, never getting demoted in 20 plus years.
Okay. And do you believe he's still doing that same thing where he is working every day and
I
working
do
for his
not
rent?
see him on a regular basis. I would have no way of knowing what he's doing at work, at home. I would have no way of knowing.
Did he make Smith his career?
Did he what?
Make Smith's
Objection
his career?
calls for
I'm just asking in
speculation.
their marriage if she knew.
Well, he
My
still
objection.
works
Whoa, whoa,
there,
whoa,
so
whoa! I made an objection. Calls for speculation as to what his intents were as to making him a career.
Did you know what he wanted to do for work as a married couple? Did you know what he wanted to do?
he's worked at Smith since he was 16. So
Did you know if he ever wanted to change out of that?
not that I'm aware.
So you knew he wanted to be a career Smith guy?
Objection. Same objection calls for
I'm
speculation.
just saying if you ever discussed it in your marriage. Did he ever talk about working anywhere else?
Not that I recall.
Thank you, we're out of time.
Thank you.
You can step down.
Thank you.
Do you wish to submit closing briefs?
Yeah, if you'd like
Yes,
to.
Your Honor, because we have a lot of numbers that are an issue, so I would love to be able to do that. But like I said, on our pretrial, we were very clear on our pretrial.
It's
said
my
not
turn
How long do
first.
you need to submit your closing
It's
briefs?
my
Okay.
turn first. It's actually my turn.
Oh, I didn't know
first.
we were going to do statements. I thought
No,
we
you're
were
not.
statements. Okay.
Judge,
Because
I-
we're out of time.
I
We're
will
way
add-
past the time.
Thank you.
And I asked, do you want to submit closing briefs?
And Your Honor, I would say I would like to submit it on our pretrial memo to keep the costs down from our for our clients because the costs are just crazy.
And Judge, I would, as to the Shriver case, 125-150, subsection 8, and Manier, and I did research last night, so I have subsequent, but some research that might be helpful as as to shed light.
I would only do it if they're going to do it. I want to keep the cost down for both parties. You let me know what we're doing, Jim.
I'm going to do it. I don't need long, Judge. I
September the
can,
11th to submit your closing briefs.
Okay,
Thank
you,
you.
Your Honor.